Hi, it's Erica Macias, and I want to walk you through this form called Residential Property Management Agreement. This is a comprehensive agreement between you as the property owner and Barrett Co, Inc., the broker, through me, Erica Macias, as the authorized agent for the management of your property. It details the terms and conditions under which we will manage your property. Description of the property. First, we'll specify the property or properties that will be managed under this agreement, attaching any necessary exhibits, especially if it's a multifamily unit or multiple properties. 1. Notices. This section outlines how all formal communications, such as notices, demands, consents, and reports, will be sent and received, requiring them to be in writing and addressed to the contact information provided for both the owner and the broker or authorized agent. 2. Engagement of broker. Engagement and acceptance. A. By signing this agreement, you engage Barrett Co, Inc. as your sole and exclusive agent to lease and manage your property. This includes listing the property and finding tenants. We accept this engagement and will provide our company services for management, and you agree to cover all reasonable expenses related to these services. My services will be performed through our authorized agents. Relationship of broker to owner. B. This agreement establishes a principal-agent relationship. We will act on your behalf, in your name, and for your account. We will operate as an independent contractor and not as your employee. Neither of us can bind the other except as explicitly stated in this agreement. We are not responsible for delays unless caused by our intentional or grossly negligent actions.
Term. The agreement's initial term will be for a specified period, typically 1 year, starting and ending on the dates we fill in. Unless terminated earlier as outlined in Section 20, it will automatically renew annually for successive 1-year periods. 3. Broker compensation and expenses. It's important to note that our compensation and commissions are negotiable and not set by law or any realtor association. Here's how we will be compensated for our services. Management fee A. You will pay us a monthly management fee, which will be the greater of a specific dollar amount or percentage of the monthly gross collected rents. If the property is vacant, a vacant property fee of $35 per month will be paid. Short periods will be prorated. Leasing fee B. When a new lease is signed, we will receive a leasing fee, which will be the greater of a set dollar amount, a percentage of the first month's rent, or a percentage of the annual rent. Additionally, a one-time non-refundable fee of $35 is paid each time a new tenant is placed. Setup fee C. A one-time, non-refundable setup fee of $400 will be charged for entering your property into our management system. Lease renewals D. For any lease renewals, a fee will be paid, either a set dollar amount, a percentage of the monthly rent, or a percentage of the annual scheduled rent. Advertising E. You agree to pay in advance for all advertising placed on your behalf. The minimum advertising fee is $35. Unless you specify otherwise in writing, we will use our reasonable discretion for all advertising, including media choice. Interest on unpaid sums F. Any amounts due to us that are not paid within 30 days will accrue interest at a rate of 18% per annum. Extraordinary services G. For tasks that are outside our customary services, such as attending eviction proceedings, HOA meetings, or compliance hearings, an hourly fee of $35 per hour will be charged. Referral or other compensation H. Any compensation we receive under this agreement is not subject to sharing with other real estate licensees who refer tenant applicants. If any referral fees are applicable, they must be covered by a separate agreement. Attorney's fees I. If we need to take legal action against you to collect amounts due under this agreement, you will be responsible for all reasonable costs and attorney's fees incurred by us. 4. Bank accounts, trust accounts A. We will establish a separate trust account for collected receipts apart from our company's corporate account at an insured institution of our choosing.
Funds in this account remain your property subject to our disbursements for expenses. Any interest earned on this account will be retained by Barrett Co, Inc. Initial deposit and reserve B. Upon signing, you will provide us with an initial reserve of $500. You need to maintain this reserve in the trust account for us to pay your obligations. We will notify you if additional funds are needed, and you must remit them within 20 days. Owner's reserve funds will be deposited into Barrett Co, Inc.'s designated bank account. 5. Collection of rents and other receipts. Broker's Authority A. We are authorized to collect all rents, charges, and other amounts on your behalf and deposit them into the trust account. Special charges B. Where permitted by law, we may collect and retain certain fees from tenants, such as administrative charges for late rent, return check fees, interest, or rental application fees. Security Deposit Trust Account C. We will maintain a separate security deposit trust account for tenant security deposits, which may hold deposits from multiple tenants. All deposits will be handled according to the lease and applicable law, including NRS Chapter 118A. Any interest earned on these security deposits will be retained by Barrett Co, Inc. Owner understands all deposits on hold for tenants will be held by Barrett Co, Inc. 6. Disbursements of rents and other receipts. Operating expenses A. We are authorized to pay for all operating expenses of the property and our compensation directly from the trust account. Debt service B. If you want us to make additional monthly payments like mortgage, taxes, or insurance premiums, you need to provide us with at least 30 days advance written notice. We may request you increase the reserve for these amounts. Net proceeds C. Any funds remaining after covering our compensation, operating costs, and replenishing the reserve will be transmitted to you as reasonably directed, with at least 30 days prior written notice from you. 7. Broker is not required to advance funds. We are not required to use our own funds to pay for disbursements or to advance any monies to you or any trust account or reserve.
8. Financial and other reports tax reporting. A. You agree to provide us with any forms required by the IRS or other taxing authorities before we disperse funds to you. Reports. B. We will provide you with a monthly statement of cash receipts and disbursements and other reports from the property's operation. We will also provide and file any legally required tax forms. Foreign Investments in Real Property Tax Act. FIRPTA C. This section addresses tax withholding requirements for non-resident alien individuals or foreign entities. You will need to indicate if you fall into this category, and we may require a written statement as per IRS code. 9. Multiple Listing Service, MLS. As a participant in Las Vegas Realtors LVR Multiple Listing Service, MLS, your property's listing information will be published and shared with other MLS participants and subscribers. We are also authorized to report the lease, its price, and terms for use by LVR members and MLS participants, unless you provide an instruction to exclude. 10. Leasing and Renting Authority. A. We are authorized to negotiate, prepare, and sign all leases, including renewals, extensions, cancellations, and modifications, on your behalf using our standard lease forms. Enforcement of the leases. B. We are authorized to initiate legal actions in your name at your cost to enforce lease terms, collect rent or other income, or evict tenants. We can sign and serve necessary notices. If needed, we may retain an attorney of our choice unless you provide the name of your attorney. Management and Maintenance Review, C. We will conduct management and maintenance reviews, inspections, and reports at the time of occupancy, when a tenant vacates, and at other times we deem necessary.
Reporting on the property's condition. In case of vacancy, we will take reasonable steps to secure the property. Key box. D. This section indicates that you do authorize us to install an electronic key box for showing the property. A key box allows authorized third parties and licensed professionals access. You acknowledge that you should remove valuables, that a key box is not an MLS requirement, that tenant consent is needed if occupied, and that you do not authorize us to issue one-day codes for access. You also acknowledge that LVR, MLS, and Barrett Co. Inc. do not insure against theft, loss, or vandalism from such access. Owner will provide at least 3 front door keys, 1 for us, 2 for tenants, and at least 2 garage door transmitters, 2 gate transmitters, 2 pool keys, 2 mailbox keys, etc.
11. Owner opt-outs MLS shares listing information with internet sites that are generally available to the public. Some of these sites may include commentary sections or automated market value estimates. You have the option to instruct us, via the MLS, not to display a commentary section or an automated estimate of value for your property. You understand that opting out could mean consumers searching online may not see your property or its address. You have marked that you do not opt out of any of these features.
12. Reasonable maintenance and repair, ordinary/emergency maintenance repair A. We will arrange for necessary repairs, maintenance, and replacements to keep the property habitable and efficient. Any costs exceeding $500 must be approved by you in advance, except in emergencies where repairs are immediately needed for preservation, safety, to avoid service suspension, or to comply with law. You authorize us to assist in scheduling work that does not require a building permit, does not exceed $10,000 every 6 months, or does not require a general contractor. Smoke detectors B. At your expense, smoke detectors will be installed in working condition before tenant occupancy as required by law. During occupancy, the tenant is responsible for maintaining them. 13. Utilities and services. Owner's responsibility. You are responsible for contracting and paying for utilities and services like electricity, gas, and water unless you designate us to do so at your expense. If a tenant fails to maintain utilities, you are responsible for re-establishing them. We have the right, but not the obligation, to contract these services and charge you. You will maintain trash and sewer services in your name. You have also initialed to authorize Barrett Co. Inc. to communicate with utility companies and make changes to services as reasonably necessary. If applicable, you agree to have a licensed pool contractor maintain the pool and a landscaping contractor maintain the sprinkler system and landscaping at your cost, which may be charged to the tenant as additional rent. The agreement indicates that you will provide pool service and will not provide landscaping service. If there is a pool, pool service will be provided and paid for by the owner, and you may request Barrett Co. Inc. to deduct payment from rent collected and pay on your behalf. If landscaping is to be provided, the monthly service fee will be deducted from monthly rent, and Barrett Co. Inc. will pay on your behalf. Owner will maintain and pay for water and power to the property until a tenant is found. 14. Insurance. Owner's insurance A. You must maintain adequate insurance against property damage and liability for loss, damage, or injury, complying with Nevada law. The deductible is your expense. We must be named as an additional insured on all liability policies, and you must provide proof within 15 days of this agreement. Liability insurance should be at least $500,000 per incident and $1 million in aggregate. You also need to provide proof of fire and adequate vandalism coverage. You must furnish us with certificates or duplicate copies of these policies within 15 days, and they must provide for at least 30 days written notice to us before cancellation or changes. If your policies lapse or fall below prescribed amounts, we have the right but not the obligation to obtain insurance for the required coverage at your expense plus a 10% administrative fee. Tenants Insurance B. This section indicates that tenants shall not be required to obtain renter's insurance. 15. Hold harmless. You agree to indemnify, defend, and hold us harmless from any losses, damages, costs, or claims incurred in connection with the property. 16. Broker assumes no liability. We do not assume liability for any damages, losses, or omissions by the tenant or for acts or omissions of you, previous owners, or previous brokers. We are not liable for tenant defaults, environmental violations, which you are responsible for curing, or the bankruptcy or failure of the depository bank where your funds are held. 17. Owner's responsibility for expenses of litigation. Litigation in compliance expenses. A. You will pay or reimburse us for fines, fees, penalties, or other expenses related to any claim or suit involving alleged violations of laws such as fair employment, fair credit reporting, environmental protection, rent control, or fair housing, unless we are found by a court to have personally violated such a law. We are not obligated to employ legal counsel to represent you. Fees for legal advice. B. You will pay reasonable expenses we incur in obtaining legal advice regarding compliance with any laws affecting the property. If such advice benefits other clients, you will pay an apportioned amount. 18. Representations. Owner representations. A. You represent and warrant that you have the full authority to enter this agreement, that there are no undisclosed agreements affecting the property, no adverse recorded easements, and that the property is zoned for its intended use. You confirm that all permits are current and the property complies with applicable laws. You also represent that any loans, notes, mortgages, taxes, dues, utilities, or trust deeds are paid in current with no defaults. You agree to report any future defaults within 14 days of receiving notice. You further represent that no liens, including HOA and super priority liens, have been recorded against the property. You understand that offering a property for lease while it's in foreclosure without written disclosure is a deceptive trade practice subject to civil and criminal penalties. Multiple listing service. B. This section clarifies that no multiple listing service, including MLS or LVR, is a party to this agreement, and none of them set, control, or suggest the amount of our compensation. 19. Common Interest Community, CIC. If your property is in a common interest community, you understand that we are not involved in or have control over the CIC. It is your sole responsibility to determine if the CIC's Declaration of Covenants, Conditions, and Restrictions, CC&Rs, restrict leasing. We assume no liability for costs related to tenancy termination or for understanding or complying with the CC&Rs or their amendments. You remain solely responsible for assessments, violations, and fees payable to the CIC, and you agree to reimburse us if we pay them on your behalf. You must provide copies of the CC&Rs for tenant compliance. If not provided, we reserve the right to secure them at your expense. The Property Information Exhibit further indicates whether your property is in a CIC and asks for details such as the management company, telephone number, dues amount and frequency, and whether you are current on dues. If the property has an HOA, the owner will provide HOA/CC&Rs to Barrett Co, Inc. with a copy for the tenant, and will sign an HOA form giving the HOA permission to speak to Barrett Co, Inc. on behalf of the owner. If the owner wants Barrett Co, Inc. to pay monthly HOA dues from rent, a coupon book needs to be provided to Barrett Co, Inc., and all dues will be paid 1 month in advance. 20. Termination. Termination/expiration. A. You can terminate this agreement early with 30 days written notice, along with a cancellation fee equal to the management fee that would accrue over the greater of the remainder of the existing lease term or this agreement's stated term. If you direct us to transfer files to a new management company, you will pay a transfer fee, which will be the lesser of $450 or $0 per hour for copying and transfer costs. We can also terminate with 30 days written notice. Within 10 days of termination, you will pay all monies due to us. If the agreement is terminated by either party before any lease is executed, we retain the setup fee, and you reimburse us for actual incurred expenses within 10 days. If you terminate before a lease is offered, you agree to pay an additional cancellation fee of $0. Owner responsible for payments. B. Upon termination, you assume all obligations for any contracts or outstanding costs incurred by us. We may withhold funds for 30 days post-termination to pay bills. Within 30 days, we will deliver any balance of monies due to you or tenant security deposits, along with a final accounting. If we receive funds payable to you after termination, we may deduct an administration fee of the greater of $0.
Leasing fee survives C. If you terminate early before a property is leased, and a property is leased within 2 calendar days after termination to someone we negotiated with or showed the property to, we are still paid the leasing fee unless you enter a valid property management agreement with another licensed broker after our agreement terminates. This indemnification survives all. Representations, warranties, and provisions requiring you to insure, defend, reimburse, or indemnify us survive the expiration or termination of this agreement. If we become involved in litigation because we were your broker, these provisions still apply. Miscellaneous rights, cumulative, no waiver. Our rights and remedies under this agreement are cumulative, meaning exercising one doesn't prevent exercising another. Failing to insist on strict performance or exercise a right doesn't waive it for future defaults. Agreement to mediate. Before any legal action, we both agree to engage in mediation with a mutually agreed upon mediator, splitting mediation fees equally. The prevailing party in any dispute will be entitled to court costs and reasonable attorney's fees. Headings are for convenience and don't affect interpretation. The agreement will be interpreted by its common meaning, not against the drafting party. No provision can be waived unless in writing and signed by both parties. Waivers are not continuing or for other provisions. The agreement can only be modified or amended by a written contract signed by both parties. Assignment, subcontracting. Neither party can assign, transfer, or subcontract the agreement without prior written approval from the other. Notices F. All notices must be in writing and delivered by specific methods: personal service, fax, email, certified mail, overnight courier. Certified mail notices are deemed given 5 days after mailing, others when received. Objections cannot be made to the delivery manner if actually received by an authorized agent. Partial invalidity G. If any provision is found invalid, void, or unenforceable, the remaining provisions will still be in full force. Publicity H. Neither party will make public announcements about this agreement without the other's approval, unless legally advised it's necessary to comply with laws. Waiver of any default I. A waiver of a default is not a waiver of subsequent defaults or a modification of the terms, unless put in writing as an amendment. 23. Applicable law. This agreement will be interpreted under Nevada state laws, and any action arising from it will be brought in a state court in the county where the property is located. 24. Complete agreement. This agreement is binding on all parties, their heirs, and assigns. No amendment is valid unless written and signed. This document contains the entire agreement between us, superseding any prior agreements, and is entered into freely and voluntarily. You represent that you have had the opportunity to consult with your own counsel and understand its contents. 25. Signatures. The agreement can be signed manually or digitally and on multiple copies, which, when combined, form one complete document. Facsimile signatures are accepted as original. 26. Additional terms and property information exhibit. This section includes specific additional terms, such as owner's reserve funds being deposited into Barrett Co. Inc.'s designated bank account. Owner will maintain and pay for water and power to the property until a tenant is found. If the property has an HOA, the owner will provide HOA/CC and Rs to Barrett Co. Inc. with a copy for the tenant and will sign an HOA form giving permission for us to speak to the HOA on your behalf. If you want us to pay monthly HOA dues from rent, a coupon book needs to be provided and all dues will be paid 1 month in advance. If there is a pool service will be provided and paid for by the owner, and you may request us to deduct payment from rent collected and pay on your behalf. If landscaping is to be provided, the monthly service fee will be deducted from monthly rent, and we will pay on your behalf. You will provide at least 3 front door keys, 2 garage door transmitters, 2 gate transmitters, 2 pool keys, and 2 mailbox keys. You understand that all tenant deposits will be held by Barrett Co. Inc., and all payments received from tenant owner are to be made payable to Barrett Co. Inc. You will also provide $200 for professional pictures for the MLS listing. The property information exhibit will detail specific information about your property, such as acceptable rental rates, lease terms, whether pets or smoking will be permitted, if Section 8 will be considered, utility details, insurance company information, including policy numbers and limits, and home warranty details. It also reiterates CIC information and allows for a list of inventory and appliances provided by you. Please let me know if you have any questions about this form before you sign it.